So this is the second pre-examination meeting for the Arecleoch extension wind farm proposal. For those of you who didn't attend the first meeting, my name is Alison Kirkwood, and I'm joined virtually by my colleague David Liddle. So we're the reporters that have been jointly appointed by Scottish ministers to conduct the inquiry. I'll firstly remind everyone present that the meeting will be recorded and will be stored as part of the DPA website archive and will be capable of repeated viewing. We have the discretion to terminate or suspend filming if, in our opinion, allowing filming would prejudice the proceedings of the meeting. By participating in the virtual meeting, you're consented to being filmed and to the use and storage of these images and sound recordings and any information pertaining to you contained in them for webcasting, training purposes, and for the purposes of keeping historical records and making those records available to the public. So further details can be found on the DPA privacy policy, which is on the DPA website. Is that okay for everybody? Okay, so I think I'm able to confirm that everyone that we're expecting is here, including Mr. Stevenson, which we thought you weren't able to attend, so that's good to see you.
I can't attend this afternoon, but I can attend this morning only.
Okay, we'll be long finished by this afternoon, so that's good. For those parties that have more than one representative, the applicant, Mr. Innes, I take it you'll be speaking for the applicant, will you?
Yes, I will. Thank you, ma'am.
And I'll maybe introduce as well, Mr. Campbell. Do you want to introduce yourself as you weren't involved last time round?
Yes, ma'am. Good morning. I'm John Campbell. I'm a Queen's Counsel at Scottish Bar, and I have instructions in this case for South Ayrshire Council from the in-house solicitor, Mrs. Christine McMenamin, who is not on this call. My client planning officers are both on leave today, so I'm afraid you have to put up with me.
I'm sure we'll be fine. Thank you very much. Mr. Innes, the other names that are on the screen, are they all representing the applicant?
Yes, and none of them will be speaking. Thank you.
That's fine. Just so we know who everybody is. I see Jane Robertson's name there as well. You'll all be very familiar with Jane. Okay, I'll quickly run through the logistics of how we'll run the meeting. As Callum has said, if you can keep your video on and turn your sound to mute, except whenever you're speaking, that'll help with any interference. Hopefully you're all on gallery view and you can see us all. We'll be able to see you, so if you want to speak anytime, just wave your hand and I'll get to you. Now I'm not sure, do we have any parties in the same room, or is everybody virtual in their own bubble? Yeah, just that's fine. Just to make sure that COVID measures are observed. And as you're aware, Callum will stay on the call and be in attendance if we need any IT support, but hopefully that won't be required. So the main purpose of today's meeting is to finalise the procedural arrangements for the oral sessions. You should have all received a copy of the agenda in advance. Everyone got an agenda? Okay, thanks. So David and I will cover the agenda between us this time. So I'll do some of the items and then pass over to David, and then I'll finish off at the end. Now we're aware that Mr. Kelly can only attend for part of the meeting, so we intend to cover the sessions that he would be involved in first before he has to leave us. Is everyone happy? Yes, Mr. Kelly.
I don't know how you're planning to take this, but I have a couple of preliminary overarching points that I would like to make, and I know that on one of them, some of the local people wish to add to the point that I'll make.
Okay, well, I was just getting to my next question was, is everyone content, and is there anything that you want to raise at this stage? So by all means, if you want to raise them now, obviously, if we know we're going to cover them later on in the agenda, we'll say that, and maybe pick up the points later on. But happy for you to raise the points you want to raise. And Mr. Bacook, I see your hand up as well.
Yes, I would like to follow on, Mr. Kelly, please.
Yeah.
Thank you.
Okay, Mr. Kelly.
A little point, which is a little bugbear of mine. I'm still thinking about how we handle it. Your minute of appointment is to conduct a public inquiry, not an examination. An examination is a term from the Planning Acts dealing with appeals, and we're not in the Planning Act world, we're in the Electricity Act world. So this is an inquiry, it's not an examination. And I'm just thinking about how we deal with previous correspondence which have gone out telling people they're taking part in an examination. It's not the case. Secondly, just in case we don't get to this point before I have to leave the meeting, and I apologise for only being available for an hour, but as I explained in an email, the move to Tier 4 has had a very severe effect on childcare arrangements for my grandchild today. We have to go and get a ferry, so sorry about that. In relation to the order of the evidence, your response was it didn't matter whether the policy hearing was last or not. I disagree, and I'll give you a very specific and live example. On Glenshero, the most contested point in the policy hearing discussion arose directly from the answers of the landscape architects in the cross-examination during the landscape evidence. If the policy hearing had been held before the landscape evidence, that debate could not have taken place. So it is important that policy is last after all of the evidence has been heard. And the final point that I know Mr. Brookott will want to come in on relates to the emails. I've been concerned for a while that there's something funny about the email circulation in this case. So I ran a little double-blind trial yesterday, and it confirmed that people are not getting the emails. And I don't know how far back this goes, but I think Mr. Brookott wants to say something more serious about it. But it does appear that we do not know who has which communications.
That's an important point to bring up, and I do have that on the next part of the agenda, because I've been looking into it I've seen the correspondence that came in yesterday and your test and the emails from Mr. Bacook. So I'll let you know where I've got to in relation to investigating it. But Mr. Bacook, do you want to come in on that?
Yes, I would, please. I just wanted to add a little bit more detail to what Ian Kelly has said. These are kind of a list of concerns that we have about the emails, and if I might just kind of go through them quite quickly. First of all, I'm not quite clear why particularly the local participants receive blind carbon copies, whereas the corporate participants don't, it would seem. I'm just not clear as to why that should be. Secondly, when you receive a blind carbon copy from the DPEA, your recipient name and address at the top don't appear on the emails. I mean, I've never encountered this before anywhere, and I would like an answer as to why that is happening. Thirdly, there still seem to be mistakes in email addresses appearing even at this stage. And quite frankly, I mean, if email systems are working properly, there shouldn't really be any excuse for mistakes appearing. And we had one this week, in fact, involving Chris Andrews there. Following on from that point, there's actually perplexity from me about how erroneous email addresses appear on sent email lists. Most people's systems, you're notified immediately before you're even able to send the email whether there's a mistake somewhere, and you have to rectify that before you can send the email out. This doesn't seem to be applying to the DPEA. Fifthly, there is actually, this is from the New Luce Community Council point of view, there is a bit of a history of mistakes in email addresses causing notification or response failures. We had, quite a significant one this year, in fact. And that was just one single letter in an email address that caused that. And lastly, just to kind of confirm Ian Kelly's point, there's complete uncertainty over who's received which emails. This is, the cross current of correspondence over the last few weeks. We're continually cutting in on, obviously, on conversations which have already taken place, which one has not been informed about. And Ian Kelly, made that point, at the beginning of this session. Thank you. Anyway, that's all I've got to add.
I'm more than happy to respond as far as I can, but it may also be a matter that we need to take back to our admin officers and investigate further on specific examples. So you'll recall that at the last meeting there was a request to set up. Sorry, Ms. Spence, do you want to respond on this, or do you want me to answer first of all?
Well, yes, I need to say something, because what has been happening is that emails that were correct are suddenly not correct. I mean, there was one particular one that I notified you about, where suddenly one of the South Ayrshire Council members had got an E in Ayrshire, the others hadn't, and suddenly that strikes me as extremely odd, particularly when it had been correct before. And I just wonder why you are meddling with the email addresses, because anybody else who creates a list of emails simply uses that and copies it when it's correct. You don't get incorrect emails in your list.
Right, we'll look into that. I'll cover the generalities first of all. A list was at the request at the last meeting. I understand that a list was put together and circulated to all parties, and for individuals requesting that they give permission for their email address to be shared with others, and I think everybody was happy with that. So I think that was sent out on the 27th of October, and then the 29th of October, a second email was sent out to add Mr. Campbell to the list on behalf of the council. So everyone should have a copy of all the correct email addresses for you all to use. Now, I understand what's been happening when the DPA have sent out the emails to all participants. In line with data protection, they've used the blind CC for individuals, and that's why individuals have had a difference than corporate. I understand that raises two issues. One, it means that people aren't aware of who's received all the email, because obviously the blind CC addresses are missing. And secondly, when then somebody does reply all, obviously, assuming that this is going back to everybody on the distribution list, it's not going back to the people on the blind CC. So I think that's where some of the confusion has arisen. Now we're aware of that. I mean, certainly going forward, we will make sure that we use a different way of meeting our data protection requirements. And to make sure that everybody gets everything, and that we're not missing people out. So, I mean, we certainly apologise if there's been correspondence going back that hasn't reached people. I mean, everybody should have everything that's gone from the DPA, because that's the corporate list. It's just, I think, when you're replying, so some of the responses obviously haven't gone to all parties, and we apologise for that. But certainly moving forward, we'll make sure that we do things differently so that doesn't happen. Ms. Crossway.
Yes, I'd just like to reiterate that we all did say that we would like our names on the top list at the beginning, so that we were all aware of who'd got what. And as you say, with blind copies, no one has any idea who's seen what, and so you can't do reply all. So I'm glad that that will be corrected from now on.
Yeah. Okay. Thank you for that, and say hopefully we've resolved that, and thanks for drawing it to our attention. Mr. Buchan, in terms of the individual issues that have been affecting the community council, if you'd like to note those down for us and send it in to Jane, we'll look into it for you, for if it matters out with this this particular.
In fact, I had raised that one particular issue this year with the DPA case officer herself, and you know, she apologized for that. But no, there shouldn't really be any reason for it.
No, you're right, and we rely so much on technology, and we rightly assume that everybody's getting it. Just sometimes it lets us down, whether it's through a glitch in the system or human error. So say we can only apologise for that, and hopefully moving forward it'll be more streamlined. Okay, in terms of the other matters raised by Mr. Kelly, I think we'll come on to the order of evidence in section 4 of the agenda, if that's okay. And in terms of your comments regarding examination and minute of appointments, maybe something we can follow on. I don't think we need to cover that within this meeting, but if you want to raise it with us afterwards, that's fine. Okay. I'll move on. So progress to date. So following the first meeting, we asked all parties to submit written statements for the topics that they wish to be involved in. So thank you to everybody for doing that. The Council has now indicated that it wishes to participate in topic 1 on policy and in topic 4 in relation to private water supplies. And Ms. Crothwaite no longer wishes to be involved in topic 2, which is the landscape and visual impact. And we have reviewed our previous decision not to take further evidence in relation to SP6 gas. And so we've added that as topic 9. So that's just an update in terms of some of the progress. The applicant and the council have been working together on suggested conditions, and they've submitted this to us in line on the 6th of November, which was in line with the timetable. So we'll cover this on the agenda in item 5 in terms of how we move that forward. Okay. So on to item 3 on the agenda, which is very current topic for everyone. So the most up-to-date DPA guidance was issued on the 3rd of November. It's due to be updated again in light of this week's announcements. This indicates that given the overall situation, our default position is that hearings and inquiries will be undertaken virtually. And obviously since this date, you'll be aware that a number of council areas are now in level 4, including South Ayrshire. When the overall situation with COVID improves, the DPA will only be holding in-person hearings and inquiries where they're considered to be absolutely essential and with very strict safety measures in place. So for instance, in relation to this case, the availability of suitably sized and COVID compliant venues would mean that even if we could have in-person proceedings, we wouldn't be able to hold them locally. There's just nowhere suitable to take place. Now, the guidance note on the DPA website refers to the recent Section 36 wind farm inquiry, which was held over 4 days. And participants in that were provided support by the DPA team to allow them to use the technology chosen to host the procedure. So we've learned quite a lot from that experience that allows cross-examination to take place virtually. but also things like having shorter days and regular breaks is essential, because it's more tiring for people to participate in virtual sessions. So this is the inquiry that I think I drew your attention to, so that you could have a look at the proceedings to sort of help answer maybe some of the questions you have about how things are working virtually. And this inquiry and the Glenshera one that Mr. Kelly has referred to are all now available on the DPA library. So you can go in and have a look at any of the sessions, just to see how a virtual inquiry and hearing sessions work. So within this context, we propose to proceed with this inquiry on the basis of virtual oral sessions. So I'm now going to hand you over to David Little, who will cover items 4 and 5 on the agenda. And this will include the potential implications of the latest COVID restrictions for our proceedings. Okay, David, over to you.
Okay, thank you, Alison. Can everyone hear me okay? Okay, great. Good morning, everyone. Yes, I'm just going to cover items 4 and 5 in the agenda. And I'll come quickly on to the points Mr. Kelly's raised and have been raised in the recent emails. Just a couple of things I just want to say first. So, as Alison was saying there, we're planning on the basis of virtual inquiries. All DPE processes are taking place that way just now. So far, we've been doing it by Zoom, which has worked for everyone. We may try and test WebEx with you. We don't necessarily have to have a discussion about that just now, but Zoom isn't available. The Scottish Government system doesn't allow Zoom to be used, so Alison and I are using this on our own personal laptops, which is fine, but when it comes to the inquiry and substantive matters, WebEx might be easier, certainly for us selfishly, because we can then have access to all the documentation using the same system. But we can come to that later. But it's just to say that we might see if WebEx works as another platform. Before I come on into Mr. Kelly's points, you will have seen that we propose an introductory session at the start of the first week. That's not what we would normally do. It seems to us like a good idea. It'll allow us to get to grips with technology in the first day, hopefully iron out any of the issues that might arise with that. And invariably, with any inquiry, there are a number of procedural matters that need to get resolved at the start of the inquiry. So we thought having a session, first of all, dealing with those things and allowing us to get inside using the technology was a good idea. So anyway, if we can move on to the more substantive issues, and Mr. Kelly, I will try and get through the issues you raised, because I know you have to go. At 11:30, is that about right, Mr. Kelly? Okay, so prior to these recent exchanges, we weren't aware of any of the other parties having expressed dissatisfaction with our proposed timescale. Now, we still think there's a way to progress matters, not with haste, but in accordance with our current guidelines, and similar to the kind of process at Glenshera. And we can talk in a minute about the arrangement for each session. But before that, I just want to give Mr. Innes, for the applicant, we've got a view from all the other parties, apart from the council, on Mr. Kelly's proposition, if you like, his schedule that he put out. But I haven't heard anything from you, Mr. Innes, yet about that. It would mean a delay from running the inquiry in January and February to starting it in March, I think. So I don't know whether other parties have said that's fine. I don't know whether they've checked the detailed dates, but I just want to get your position on that before we start to get into the arrangements for each session.
Yeah, well, thank you, Sarah. In terms of this process, this was kicked off in May of this year when the papers were passed to DPA. And there is always a gap between those papers being passed, reporters being appointed, and the proceedings commencing. In September of this year, we held the first of a pre-examination meeting. At that pre-examination meeting, I predicted that it was likely that COVID restrictions would be applicable at the time when we would potentially be having to have proceedings, and that as a consequence of that, the applicant was prepared to put quite a lot of effort into the upfront disclosure of its case, because one of the lessons learned from conducting virtual proceedings is that essentially it does take longer to deal with the same issue, the breaks, etc. So we set out a process where the applicant would take a lot of responsibility for disclosing their precise position up front. The purpose of that was to enable other parties who were in the proceedings to understand where the applicant was coming from in policy, landscape and visual, to make it easier for them to be able to respond to matters in a focused manner. Equally, we undertook to do things like push on with getting a core document list produced, and also work with the council in relation to producing a set of conditions. And I'm very grateful for the work which the council officers have undertaken in enabling us to meet those relatively tight deadlines that were set. But that means that in terms of the process, in terms of where I'm coming from and setting out the applicant's position, we're at a fairly advanced stage of setting out exactly where we're coming from in relation to this inquiry, responding to the objections as they've been currently put, all with an aim to try and bring the proceedings to a more focused process. And in terms of the response that we've received, certain parties are engaged very actively in the process, and I would highlight Mr. Stevenson, who is engaged very proactively in the process and the topic matters that he is particularly interested in. And I think if you look at the various exchanges that we've had, those issues are now relatively far advanced in understanding the relative parties' positions in relation to matters. In relation to other aspects, I think the case is less advanced, and parties have chosen to perhaps not engage as actively as Mr. Stevens done. And that's perfectly fine, but it does have consequences for where we are and where we stand. The original intention was to hold the proceedings towards the end of this year. And that's now not going to happen. We're moving into January. We then got canvassed on dates, and there was quite a lot of difficulties with dates. And as reporters, you've allowed parties who perhaps had a witness difficulty to shift the date to enable that to facilitate that to happen. And that was all fixed. And as far as the applicants are concerned, we have also shifted dates to make ourselves available for the dates that were suggested. And so now, at this very late stage, for an entirely new programme to be put forward is, in my submission, not appropriate. The parties have confirmed they're available for these dates. And in my submission, the key issue here is to ensure that those proceedings are conducted in a fair and an appropriate manner, given where we are at the current time. And I think there is time before these various hearing sessions and inquiry sessions that have been fixed for that to be undertaken. And equally, the impression I get from part of Mr. Kelly's position is that he's not ready to go to these proceedings, which I find quite remarkable, given that we've had such a long lead-in time. And in terms of the process, as I say, the applicants have set out their case very early in this process. And therefore, in my submission, I don't think there's any reason as to why we should now be canvassing a substantial delay. And equally, I know issues in March, and part of that arises because the commitments I've already made to these other dates. And simply put, what will end up is keep pushing this back, and it's not fair. And the question is there a prejudice by delay? And I'm going to say, yes, absolutely, there is a prejudice, and I'll tell you why. The UK government has changed policy, and insofar as onshore wind is now concerned, it is going to be potentially eligible to bid into new rounds of market support at the end of next year. And I think it's perfectly reasonable, having lodged an application in June 2019, for that decision, for decisions in relation to this application, to potentially be taken in the timescales, which would enable, if successful, and I'm not prejudging that outcome, that it could participate in those auctions, which are likely to occur in the latter part of next year. And simply put, the delays to this process could prejudice that. So there is, from the applicant's position, a real threat to real prejudice in terms of potentially being able to deliver the projects as they would potentially like to do so. So I don't see there's any reason at this stage to be abandoning the procedures that we've been working towards, because simply put, we have been working towards these dates, and it's not right that essentially the process should be brought to a halt by one party trying to direct that proceedings should be conducted in a particular manner. You, as reporters, have both been jointly appointed to conduct the inquiry, and in my submission, it's for you to work, having heard parties in relation to those procedures, and I and my clients are happy to stand by the procedural decisions that you've taken. We have met all the procedural decisions that you've taken to date and appreciate the importance of doing so. And we would expect the manner to proceed as was anticipated in the first pre-examination meeting. There's nothing really more I can add to that, but I think we are capable of having perfectly fair proceedings conducted in the dates that you've set out, and which have been already extensively consulted upon in terms of availability. I don't really think there's anything more I can add to that, but that's the applicant's position.
Okay, thank you, Mr. Innes. Mr. Kelly, I saw you put your hand up there. I'll come back to you in a second. What I'm going to suggest is, rather than having this discussion in general terms, because we have different sessions with different participants, I think what I'd like to do is go through each one and talk about the arrangements we've put in place. And because different people, not everyone has got the same interest, if you like, in the same session. But so with that caveat, Mr. Kelly, have you got a point to make, or can we just have this discussion about policy, then about landscape and visual impacts and so forth? Carry on, Mr. Kelly.
I would invite Mr. Innes to withdraw his insulting comment about me not being ready. I will meet any date set by the reporters. My approach to this case is entirely driven by the experience. There's been two semi-virtual public inquiries under Section 36 and two full virtual inquiries. I've taken part in 3 out of the 4 of them. As far as I'm aware, there's no other person participating in this call who has any direct experience of virtual inquiries. A tremendous amount of effort went in by a whole load of people, especially the applicants at Glensherrow, to come up with that protocol and timing. And I stressed that in my email last night. This was driven by the applicants to make a successful process. Glensherrow worked. It really did work and address all the challenges, and that's why I've put it to you. But having made that point, I'm happy to proceed as you suggested, sir.
Okay, thank you, Mr. Kelly. Right, yes, I've taken part in 5 virtual hearings, but I haven't had the benefit of doing an inquiry, and appreciate that there are differences in the procedures. Okay, if then we can, let me just find my notes. Yeah, if we can maybe move on to session 1 then, so on policy and related matters. So this will be a hearing, and we've allowed a full day for it. I mean, I hear what you say, Mr. Kelly, about what happened at Glensherrow, and I'm happy to ask. I'll come back to the other participants in session 1 on that point. I've certainly had public inquiries and hearings where, or sessions where I've done policy first, and it's worked perfectly fine. I understand there might be examples where it's better to come last, but if we just park that for a second. And of course, just a reminder for all of us taking part in this session, it's about how policy should be applied to this case, not a discussion about the merits or otherwise of Scottish Government energy policy, SPP and so forth. That's not what we've been appointed to do. So we've got the statements of case on policy and the related matters. We've built in a timetable for the exchange of documents running up to our proposed date, which was the 12th of January. Mr. Kelly would be representing his clients. Helen McDade would be the witness for Ms. Crothwaite, and Alison McGibbon for the council. Mr. Arecleoch and Mr. Andrews are also to participate, as would the applicant. So let's assume it's the 12th of January for the moment. Mr. Kelly, you said that you'd like the deadline for exchanges of the hearing statements pushed back from the 27th of November. And as I think we noted in our email exchange, or our email that went out yesterday, I think, and we're content with that. If delaying, if we do proceed on the 12th of January, if delaying that by a week or by 2 weeks is more helpful for the parties, then that's fine. So would a week's delay, Mr. Kelly, be sufficient? I mean, you said there that you would comply with whatever deadline we set, but I want to try and have arrangements that work for everyone. If we change that deadline back to the 4th of December, would that be sufficient for you, or would you need another week to the 11th of December? I'm just trying to get a feel for what your requirements are there.
Learning the lessons from Glenshero, the key is actually in meeting deadlines, setting deadlines and meeting deadlines, is the availability of the documentation. To reach the policy conclusions on landscape and visual matters, I would need the hard copy visualizations from the original EIA, and I would also need to see the updated landscape and visual impact assessment, including the updated cumulative wildland impact assessment. So the key thing in terms of setting dates for the hearing statements, inquiry reports and precognitions is the availability of documentation in hard and electronic form. And certainly the procedures adopted at Glenshero let us all easily meet the dates because the documentation was available to everyone. So off the top of my head, I can't answer your question. It's dependent on the availability of the documentation. And everybody needs to see the documentation, the basic documentation to move forward with these things. So once the documentation is available, hearing statements can be turned around very quickly.
Okay, so I mean, all the documentation's on our website, and that's how I've been accessing it. We have hard copies of the visualizations. So I just so to understand, Mr. Kelly, what is it you can't get access to that you need? Is it simply the hard copies of the visualizations and that kind of material?
So it's a hard copy of the visualizations, and in all 3 virtual cases I've been involved in to date, the applicants have very timorously provided the hard copies of the visualizations. In fact, they've been excellent at distributing the material. So it really is the hard copy visualizations as they stand just now, and as they have to be updated for updated cumulative effects. Okay, sorry, I should just say it. I'm happy to work electronically with everything else except the visual material.
Okay, I'm grateful for that. I'll come back to Mr. Innes in a moment. So in terms of the policy session, your intention would be to draw policy conclusions, if you like, as to the acceptability or otherwise of the wind farm, and present those in the policy session, rather than dealing with that kind of issue through the landscape and visual session or in closing submissions. There's one can see it either way. You know, you can have the policy session more abstractly, which is about what do these policies mean and how do they apply, and then ultimately it's for Alison and I to take policy conclusions, and for ministers. So I just wonder, does the debate on policy require the detailed knowledge of the detailed sight of those visualizations? But anyway, before I come back to that, I suppose I'm just going to go to Mr. Innes then. I was going to raise this issue earlier, but Mr. Innes, Mr. Kelly's made that request. We have the benefit of the hard copy visualizations, and they're very useful. I don't know whether other participants would make the same request for those documents. But would you be able to provide those for Mr. Kelly and others if they ask for it, and when, if so?
Yes, they're quite voluminous if we're asking, because as I understand it, what he's looking for is a hard copy of the landscape and visual material relative to the Arecleoch extension, Clochry, and I think it might be the Kilgalliach extension as well.
Well, what I have is the EIA and nothing else. So I assume what we were talking about, and I should have mentioned that Mr. Kelly is referring to updated cumulative assessments. We've not. My understanding is your position is that you are not proposing to provide any. Now, people can make submissions about that and what that means for the evidence. That's fine, but that's your intention. So what I was talking about was providing. I can't remember what appendix or what volume of the EIA is, but whatever it is from the EIA, which contains the visualization material. So if that's what we're talking about, when would you be able to provide those, Mike?
If I could perhaps deal with this once, and we'll come back to wider documents. In terms of that documentation, my understanding is Mr. Kelly wants the Arecleoch extension and also hard copies of the Clochry material as well, because I'm going to be, as I indicated in our letter of the 2nd of October, we would be lodging that material, and there's been also a request, because matters have been raised in relation to it, to also raise the Kilgalliach wind farm extension. All 3 sets of hard copy will be provided to Mr. Kelly because he has raised these issues. We were anticipating that these he would want those sooner rather than later, and therefore we were going to put them on the core document list, which requires to be submitted next Friday. And that was our intention for Mr. Kelly if he's requested. It is a fairly big burden in terms of the volume of copying, but we're happy to make that commitment because Mr. Kelly wants to go off and use that material, and that's absolutely fine. So that is our intention, is to make that available to him on Friday next week.
Okay, thank you, Mr. Ennis. So he would be provided with hard copies of that material on Friday.
Yeah.
Okay.
Does that mean, may I ask a question?
Yes, of course, Mr. Campbell.
Does that mean that material will be available on either the DPA website or the applicant's website next Friday?
Well, I'm going to come to that, and I'm going to probably address that. Mr. Kelly's talked a lot about sticks. We're happy to potentially provide material on sticks, which can be sent out to individuals if they want that. We're also, we as a firm operate what we call a hub, which is essentially a website which people can be given controlled access to. You sign in and you get access to the documentation that we can load. We are happy to set that up as well. What is I mean, the way in which the DPA website operates makes it quite difficult to potentially have a list of things and search them, etc. Whereas these hubs are sort of built around accessibility documentation rather than public disclosure of a sort of vast amount. We're happy to try and trial that to see if people find that useful. That's what we propose to do. And equally, it means that those that want access have to request it. They get sent an email with and an access to it. That is a tool which we think may be useful in the virtual world, but we understand that some people may want to have it hard copy in the sense of a digital stick that they can stick in and then download to the computer. It's a choice because you can go onto this website and download material, or you can take a stick and download it. I mean, one of the issues professionally is that we generally, a lot of professional organizations have problems using sticks because of the data protection issues. So, for example, a lot of professional people have, it's not enabled on the laptops to use sticks. So therefore, we're happy to choose, and that seems to me to be a good balance between the two. So you can access material and also potentially, if you request it, want to have a stick, you can download it. So, and if Mr. Kelly wants hard copies of those 3 things, we'll arrange for it. I mean, we can achieve that.
Thank you. If I may say so, that's an expedient which should be commended. Unlike Mr. Kelly, I've done 9 inquiries or tribunals now in this way, and in 8 of them, that method was used. It's perfectly straightforward. You log into the site, you get the document you want, you either download it or read it, and then you log out again. So it's a ready resource. It just takes practice.
Okay.
So I'm grateful to Mr. Innes for that offer, and on behalf of the council, very happy to take it up. Thank you.
I see 2 hands up there, Ms. Spence and Ms. Ellis. Can we come back to this issue of documents?
Yes.
Because it's a general point, and I'm conscious of Mr. Kelly's time, and so we will come back to this issue because it relates to all the sessions, not just to this one. Dealing with policy and Mr. Kelly, if you have this material on the 27th, when do you think you'd be in a position to provide your hearing statement on policy matters? I'd initially suggested a week, but delaying it a week, but that only then gives you a week to respond. So how would the 11th of December be, which is 2 weeks?
If I get the stuff on the 4th of December, then 2 weeks takes us to the 18th, not the 11th.
I thought Mr. Innes said you would get it on the 27th, though.
Well, Mr. Innes said I would get the hard copy material on the 4th.
No, 27th.
We'll try and get it to you if you give us your address. You're in the Glasgow area, so that's potential. Outside that, we can't guarantee it so quickly. But you're in the Glasgow area. We can seek to arrange for those papers to be delivered to you.
Sir,
and if it helps, I'm happy for the 18th. I mean, I take Mr. Kelly's point that rushing things is not necessarily the right thing. If Mr. Kelly wants the 18th, I have no problem with extending it to the 18th. That seems, often it's better to get a better quality thing at that time than to push in 2 weeks. So if Mr. Kelly thinks that's more realistic, I have no issue with that.
I'm sorry, I was muted there. Okay, that's fine. The intention is to get it, but to Mr. Kelly by the 27th. So let's assume it's there on or about that date. The 18th isn't necessarily a problem for us either. The only knock-on effect is our ability to then get a hearing agenda out to you. I'll be working over the Christmas period. I don't mind doing that work after we get the hearing statements, so you might get the hearing agenda a little bit later than we promised, but I think we can work around that. Mr. Kelly, on the other point about the date, my suggestion, my feeling is that I want to proceed because I've done it before by having policy first. I think I hear what you say, that it can be useful having it last, but it can also be useful having it first because it sets in context for what you then want to discuss in more detail. I'm going to propose that we stick to the 12th of January. If it turns out subsequently that issues arise that compel us to think about policy again, then my suggestion is, well, we'll deal with that if that arises. But Mr. Innes, do you have a view on whether policy's first or last, or whether it matters?
Well, policy sets the scene, and I think there's a lot of value in setting the scene. Equally, if there are policy matters that arise, all parties are given the opportunity to do a closing submission. That closing submission is based on the totality of evidence before the process. And if there's a matter arises in other evidence, you're perfectly entitled to put that in your closing submission and relate it to policy. That's not new evidence. That is utterly entitled to do that. So if a matter does arise, it can be addressed in closing submission. or if there were a particular matter that it was felt needed to be clarified, we are going to be in a second week of proceedings where there could be an opportunity afforded to revisit a matter if that was deemed necessary.
Okay, thank you, Mr. Innes. Now, there are other participants in the policy session, and I'm not ignoring them, and I'll come back to this, but Mr. Kelly, you need to go pretty soon. So if I may, before you do that, can we, I just want to come back to your other point, which is about the landscape and visual sessions, Tier 4 in South Ayrshire, and how that affects your ability to prepare for the inquiry. So can, I guess it's a difficult question to answer just now because we're making a lot of assumptions, but what are you saying is, were you intended to go outside with the visualizations and truth what you're seeing? I don't think you're going to be bringing in a landscape consultant. My understanding is you'd be doing this yourself. I just want to understand what difficulties these new restrictions in South Ayrshire place on your ability to participate or to prepare rather for the session 2 that we've slotted in 1st of February. You're muted, Mr. Kelly. I can't hear you.
Sorry, sir. The process I follow is one of looking at the hard copy visualizations and then deciding based on them whether there are any viewpoints that I need to visit to, if you like, proof check the material I'm seeing in front of me. I've already undertaken general site visits prior to the lockdown. I know the area well. So I really was just flagging up a potential concern. It might be that once I've gone through all the visualizations, I decide that I don't need to go and look at anything. But if I did, then obviously the current restrictions would apply. I'm quite happy that you proceed, but just accept that there's a caveat that it might not be possible to undertake site work. I mean, I don't know if this is going to affect any other areas of evidence. For example, the council are now looking to lead evidence of private water supplies. I don't know whether site visits would be needed in connection with private water supplies. If we're not following the Glen Sherrill protocol that all of the local objectors have signed up to, then I suggest that you just proceed as planned. And I will hope that the visualizations are adequate. If I felt there was a need for a site visit, it might be possible in January. I might need to send in a short supplementary statement. But if you were willing to be flexible in these points, sir, then I would not ask you to change the timescales.
Okay, thank you, Mr. Kelly. Well, I'm very grateful for that. Yes, indeed, flexibility might be our watchword given everything that's happening. Can I ask, Mr. Kelly, would your proposal to be, you maybe don't know just now, but would you be proposing to submit an inquiry report, as we often see on landscape and visual matters, and then a shorter precognition, or would it just be your precognition that you'd be preparing for? Because I can see how that might impinge upon these timeframes, depending on what your intention is.
Based on the experience at Glen Sherrill, we are not leading a professional landscape architect. We are looking to the council to lead in that regard with Carol Anderson. I'm very well aware of her work and very happy with that. My current thinking is that I would be looking to submit a very short inquiry report and a short precognition. The purpose of both of them would be to illuminate the policy conclusions that I reach. It would not be a major area of evidence for us. It would be designed to tie into the policy conclusions.
Okay, thank you. Right, that's understood. And if proceeding as we are, if it turns out that things are tight, and you need to get out on site, and that impinges upon those deadlines, then yeah, we'll then need to think about what can we provide a bit of flexibility just to allow you and others to do that. Okay, thank you. That's very helpful. It might be, of course, that and you probably won't hear it now because you have to go. It might be that the council have issues because I don't know whether Ms Anderson needs to get out on site or indeed the applicant. I'll find that out soon. I'm not sure at what point this the video of this meeting will be available for you to view. We'll get our note out as soon as possible. But Jane, the case officer, is on leave next week, but somebody will be filling in for her, if you like, or covering her inbox. So Alison and I will just have a think after this and think about the best way we can make sure you're put back up to speed as to what happens to the rest of this session now that you're having to leave. Before you do, Mr. Kelly, is there anything else that's pressing you wanted to say just now that we haven't covered yet?
You're muted, Mr. Kelly. You're muted.
Can you hear me now?
Yes.
Yes, thank you. No, there's nothing. I've looked at my notes. There's nothing else I need to raise just now. So,
may I ask Mr. Kelly a question before he leaves? Thank you very much. Would you be clear who you act for, please, and what interests you represent? Sometimes you speak for local people, sometimes you speak for your client, the Wellington Estates. Sometimes it's not clear. Could I just be crystal clear what interest you are representing in this inquiry?
yes, I'm happy to clarify. I act for the Wellington Estates, and my clients have asked me to give help to the local objectors on procedural matters, which I do, but I am not instructed or engaged by any of these local parties. My role is simply, as asked by my client, to help them on procedure.
Thank you, that's very helpful. We'll leave metaphors about the Battle of Waterloo for the moment.
Okay, thank you, Mr. Kelly. We'll be back in touch hopefully soon. Thank you. Okay, let me just gather my thoughts and establish where we were. So yes.
Sir, could just matter on the coronavirus. Yes, in terms of obviously we wait. The regulations are actually very complicated to look at because there's been a never-ending series of amendments, and it's not straightforward to look through them. And so quite often you'll reach a section where something is prohibited, and on one view you then say, well, I can't do that. But then in subsequent parts of the regulations, you'll find that there is a defense. And currently running through a lot of the regulations has been a defense to work or provide voluntary or charitable services where it's not possible for the person to do so from home. That has been used by numerous people to carry on doing work and provides a potential defense to travel issues. Of course, each individual will have to look at that in their own context, but there is generally not a prohibition on doing work if you can't do it from home. And so the issue in some respects here is not actually those who are engaged or working, but those who perhaps are essentially lay people. And whilst you're allowed to still travel within your council area, moving council boundaries is currently the issue. But equally, if people were encountering problems and they wanted to, say, go to a viewpoint and they were living outside a county boundary, then I do think there might be a possibility that the DPA could indicate that these proceedings are ongoing, that it is in the public interest that these proceedings are ongoing. And if people needed to understand or get something from the DPA that these are proceedings and that people might need to visit things, that something could be done. I mean, as I understand, the police are applying these regulations with a degree of understanding and context. And I don't view an individual who may not be being paid participating in a public inquiry to have had any different interest in being able to do and to travel and potentially do something in the context of preparation. But it may be that that's something that consideration could be given to and taken up. And equally, we are at quite an advanced stage in this process. So again, you know, a lot of these issues should have been addressed as in the run-up. We're at the stage of finalising evidence rather than starting from scratch. But I just flag that professionally that there may well be opportunities, but equally, it's up to each employer to do their own risk assessment. And that's a further issue that will obviously potentially influence the ability of employed persons to actually do things. Because again, most businesses are currently conducting risk assessments relative to activities as well. So again, if people are encountering difficulties, they should come back probably through to the DPA. But I don't think there's an absolute embargo or an impediment to people still being able to do certain aspects of inquiry preparation work.
Okay, thank you, Mr. Ennis. Yes, I'll come on to the detail. Yeah, sorry, Alison, yes.
Yeah, if I could just, I'm going to cover site inspections later on in the agenda, but just to respond to what Mr. Ennis says, the current DPA policy is that reporters are not doing site visits in level 4 areas. Yeah. That's the risk assessment that has been undertaken for ourselves. So it would be unlikely that we would be encouraging other people to go to areas that we can't go to. But obviously the timescales for the level 4 are up until I think the 11th of December at the minute. So there still is party, and I think the majority of, if not all, the other parties here all live within South Ayrshire, so they would be able to move. Is that correct? There's none of you are out with South Ayrshire, are you?
Yes, I am.
Right.
I'm in Wigtonshire, so we're level 2, not level 4.
Okay, well, we can have a discussion about how that impacts.
Miss Anderson, Carol Anderson, who's working for the council, and myself both live outside South Ayrshire as well. We were planning a visit next week, but I think that's off now because it's not possible. So we won't know until the 11th of December.
Okay, thank you, Alison. Yes, I mean, Mr. Ennis, we as DPA overall, we keep all these things under review, of course. You're right in terms of regulations and what's permissible, but you know, we're very clear as civil servants that we're being asked to observe the spirit, not just the detail of the regulations, and certainly the DPA on behalf of the government doesn't want to be asking people to you know, put other people at risk to make journeys which aren't necessary. On the other hand, as you rightly point out, there's a public interest in keeping the business of government going at the same time, and it's just finding a balance between those two things. So,
and can I just say that I would add to the issue that if there is issues, that we can obviously provide flexibility within the process to accommodate them. If at the end of the day somebody was only in the week before the landscape session able to go and visit a site and wanted to raise a point as a consequence of that, then absolutely fine. I think that's the sort of spirit of flexibility that's required in the current climate. And I think what we're really after is what if we can make sure that we've got the main cases put forward. If there are aspects around the edge of that where somebody wants to go and check something, absolutely fine. But I think by this stage of the process, most people should know the main arguments which they wish to put forward and their thoughts. And it really comes down to those bits about, well, somebody's put that point, I want to go and check that. Well, that may be something that you know, can come later and respect the flexibility of the process in that regard.
Okay, that's good. And yeah, and if we all approach it in that spirit, that would be helpful. So before I move on from policy, though, I just want to check. Ms. Crosby and Mr. McGibbon, and indeed Mr. Campbell for the council. What we have is a process as set out in our earlier notes. We've agreed though that we can move the hearing statements back until the 18th of December, with a possible consequence of a slightly later hearing agenda. Are we content to move on, leave policy like that and move on to landscape and visual impacts? If you can just raise your hand if there's a problem with that. Mr. Buckle.
Yeah. I mean, I would prefer to stick to the 12th of Jan on that one. Obviously I can do the 18th of December, but my diary is getting complicated at that time.
No, I'm sorry. My apologies. I probably misspoke there. All I meant was it was delaying the exchange of the hearing statements until the 18th of December, but still going with the 12th for the actual hearing itself.
So, in actual fact, then I might need to be very much involved in that anyway. I mean, I've produced hearing statements already. Presumably, they would then just be made available to all other participants. Though I do recall that I've actually copied copies of the hearing statements to interested parties with respect to those particular policy areas. So I would think that most people already had my position statement on that. Anyway, I just wanted to raise that point.
Yeah, we'll clarify that on submissions, but it may well be that parties don't wish to submit additional statements for the hearings, that all the work that you did in relation to your written statements may cover everything you want to say, or you may have something short that you want to add to that, but you don't need to add to that. And I think we in our timetable we set out, it was very much for the parties who wish to submit additional. I think, as Mr. Innes said, some people have already submitted very full written statements, others haven't yet, so they maybe want to put more in their hearing statements.
Yes, it's an opportunity, not an obligation. Mr. Campbell, you, I think when I asked that question, did you also raise your hand, or are you content with how we leave it with policy?
No, I was a little quick to raise my hand. I have nothing to say on this. Just go with whatever date you go with.
Okay, thank you.
I'm not pushing for a particular earlier or later date. I'm quite happy to just go with the flow, whatever you decide.
Okay, thank you. So if we can move back then, rather than on to the session 2, which was landscape and visual impacts. Just to recap, Mr. Kelly said, well, there might be some difficulty if he needs to go out and truth or check again some of the viewpoints, but there might not be. So he was happy to proceed on that basis, and on with the expectation that if as Mr. Innes suggested, that if that means we might get additional evidence coming in late because somebody's then had the chance to go out and check something, then so be it. If we approach that in the right spirit, that should be fine. So that was Mr. Kelly's. That's how we left it with him. Mr. Campbell, obviously, Ms. Anderson's going to be presenting the council's landscape evidence. Do you foresee Tier 4 and COVID and then holidays being an issue in terms of her ability to meet the timescales that we?
Until Tier 4 was imposed on South Ayrshire, there was no perceptible difficulty. Now, I haven't asked her about this, and she's not on this call, but it's permissible to go to work in a Tier 4 area, and it's permissible to cross boundaries for that reason, as I understand the regulations, provided COVID restrictions are observed. So I think the idea of a joint trip with her and myself is probably fading. We probably just do it individually when the time permits. But no, I don't, to answer your question, I don't perceive any difficulty with those dates.
Thank you, Mr. Campbell. Okay, well, that's good. We seem at present.
Sorry, if I could add one thing. She is, of course, the author of the capacity study and the guidance, and is very, very familiar with the area. So I don't expect that she will need to spend very long. In this case, the Clockery case is a different matter altogether, but we're not talking about that today.
No, and I'm thankful for that. I'm just looking up though. So far, for the three protagonists that we've discussed, we don't seem to have any insurmountable problems with carrying on as we'd suggested. And here, if we're just talking about one's ability to prepare, does anyone else get concerns about the restrictions and their ability to meet the target dates and the deadlines that we'd set for the evidence? Can you raise your hand if you want to. And I mean on landscape and visual, we'll come on to the other issues later. Okay, that's good. I'll just need to check my notes to see what I was going to ask next. And I'd just say, Alison, if I inadvertently missed something, then just pull me up on it, please. Just to take note. Okay. Yeah. One question I was going to ask, and it's an unfair one at this point, I know, but we've slotted in 3 days for the evidence. Now, I just, hopefully that's enough, but I just want to ask the question, do people have got any concerns that we might not be able to get through the evidence in 3 days? There are obviously a number of people wishing to give evidence and maybe cross-examine. We're doing it virtually, which imposes certain strictures, if you like. Mr. Innes, from your experience, first of all, do you think 3 days is realistic?
Yes, I do. I suppose at the end of the day, my real role is in terms of the timings, cross-examining all the other participants. I understand the nature of these proceedings, and I also understand the limitations, the consequences that any cross-examination would be pretty focused. The other aspect which I would highlight is that the differences between the applicant's landscape consultant and the council's are quite focused. And I certainly think from the written submissions, hopefully that came across. And that actually greatly assists in the sense of we've got that levels of disagreement are important in the sense of we can save a lot of time from doing that. And I think in that case, that tends to lead to a much shorter cross-examination. I've yet to, of course, see the rest of the evidence, but equally, I think 3 days is appropriate and should be ample time to complete the process, even in the restricted format.
I agree. I agree with that, without any elaboration. You're muted. Sorry, you're muted.
I beg your pardon. Yeah, it seems to us like it should be enough, but I just wanted to give that opportunity. If anyone else wants to say anything about that, then do so, please. Okay. Right, that's excellent. Thank you. If we can move on, and hopefully the next sessions will be a bit quicker. I don't want to take too much of you more time than I need to. Session
Could
4.
we perhaps just work out the timings of those? I mean, is it as set out, which is the documents lodged on the 6th and preconditions on the 8th? Because I think Mr. Kelly expressed a concern in his representations about there not being a gap between potentially receiving a document and having to write a precondition on it.
If we can maybe come back to that under the submissions item on the agenda, and if we can run through. So hold that thought.
I was just making it was one of Mr. Kelly's points, and I didn't want that to be missed.
No,
given the fact they had to go for.
I've got a note of that for
Yep.
for that bit, so we'll cover it then.
Thank you.
3 days, 1 to 3 February.
David, Miss Ellis wants to speak.
It was just that before we leave, it was just that while we're still on landscape and visual, I had asked the applicants for a new wireline from a viewing point some time ago, and I just wondered if they were able to provide that or not. I haven't heard any more about it.
Ms. Ellis, I didn't hear all of that. I don't know whether Mr. Innes did, but I do recall you. I do recall you saying that in one of your earlier submissions. What it might be that if you turn your video off, we're better able to hear you. I don't know if others had the same problem, but my understanding is that well, I've not heard that the applicant
Is this better without the video?
Yes, I can.
Can you hear me?
Yes,
yeah.
I can.
It was just I wondered. I hadn't heard any more about it, and I just wondered if there would be a wireline forthcoming, or it's not something that can be done. Just so I know, one way or the other.
Mr. Innes, I don't know if you can answer that question.
Not off the top of my head. I will take instructions and come back on that matter. I don't have a position as to what can and can't be done at the moment. Thanks.
Okay, that's fine. I'll just wait and see at the moment then. Thank you.
Okay. Well, thank you both for that. Hopefully we can resolve that one way or the other. Okay, moving on then to hydrology. We've suggested an inquiry session due to the potential technical nature of the evidence. Mr. Campbell, you've now confirmed that the council will participate as an objector in relation to private water supplies. Do you know? I don't want to discuss it in any detail, but I just want to understand, just for going forward, why the council's position's changed, and maybe do you know how many witnesses the council would want to field on this point?
Yes, I can answer both of those questions. The answer to the first question is, on reviewing the environmental statement, I had a number of questions for my clients, which they put to the relevant department. And the relevant department came back and said, we would like to look at this for a few days and come back to you. And in those few days, they conducted some field work. They then came back to us and said that here was a list of what they perceived to be unanswered questions. I don't call them problems because they may not be, but unanswered questions. And on that basis, because time is at a premium, I intimated the council's interest in that subject. So that's the reason why the council has ostensibly changed its mind, at least insofar as objecting is concerned. And I don't say that that's the last word on it, but I think it will be. The second is that the witness, there will be one, as matters presently stand, one witness from the council's environmental health department. There may be two, because I'm looking at the moment at the possibility of securing the services of an expert to sit alongside the environmental health officer. And we haven't reached a view yet about that, but I expect we will in the course of the next few days. Taking those things together, I can't see this evidence lasting, from the council's point of view, more than half a day. and that does not include cross-examination. I know that Mr. Innes is accustomed to focusing his cross-examination, and so we are probably looking, I'll stick my neck out and say 3/4 of a day at the most on this topic. Particularly, I've asked for some GIS work to be done so that you have some illustrated material, which makes it much easier to follow.
Okay, thank you, Mr. Campbell. Mr. Innes, I was just going to ask you how many witnesses you would have, but you might not know because you don't know the council's position yet.
Well,
I don't know if you get anything to say in response.
Yeah, so I've got 2 points to make. First is that obviously it's not just the council that is interested in this matter. Susan Crothwaite has set out an outline statement of case. The outline statement of case is exceptionally generic in the sense of it doesn't really give me the meat of what the objection is on private water supplies. The difficulty with all this is that part of this process, prior notice, fair notice, and on a technical subject such as this, it is essential that a general statement that they have concerns or that there isn't enough mitigation, etc., is not really giving fair notice. And equally, in terms of the council's position, I appreciate Mr. Campbell's come into this late, that this is quite late for the council to be commissioning further work and to potentially be coming up with further matters. I obviously will reserve my position once we've seen the information and whatever may come from it. But insofar as disclosure is concerned, I would encourage on the private water supply as early a disclosure as possible in relation to these matters to ensure that I have a proper ability to take an instruction and to be briefed. In terms of witnesses, I would anticipate that I would have a single witness who would be a hydrologist who had been involved in the assessment. Again, hard to say how long these take, but it depends on what information comes forward. And at the moment, I'm currently faced with a bit of a blancmange in terms of what exactly is the case on private water supply. And having dealt with this elsewhere, the key issue, as I say, is prior disclosure. And the second point that I was going to make here is that given the nature and the timing of this, my invitation would be to invite the objector and potentially the council to lead their evidence first and for the applicant to respond to it. In essence, we've reached a position that's been fairly far advanced, and we're now met with a fairly uncertain case. And this is a submission I'm also going to make in relation to noise. And I think it's quite proper that the applicant should respond to these objections rather than going first and putting their case, as it were, because this is really being driven by an objection. And it then means why it's unfair is particularly in relation to these matters is that I should really be responding to this rather than setting the scene on this, because I've set my material out ages ago, and I just make that, and certainly in a virtual context, I don't think that should make a particular problem, but I just flag that as I think being a fair way of dealing with this to make sure that my witness is actually responding to the matter rather than having to take the lead on matters, given the way in which these matters are evolving.
Okay, I mean, you would, Mr. Innes, of course, have the benefit of documentation, recognition. I don't know whether there's going to be an inquiry report, but even then, your preference would be to go second or go last, if you like, on these sessions.
Yeah.
Let me come to Ms. Crothwaite then. So you have Dr. Connor as your witness. Can I ask, are you planning to give oral evidence in the form of a precognition and delivering that at the inquiry session, or would you be leaving the giving of evidence to Dr. Connor?
Well, first of all, can I just discuss the matter of statement of case and the full report? The guidance that I've received is that the statement of case is just a very outline of what you've put in your objection, and then the full report comes later. Now, I haven't been involved in a full inquiry before, and so I can only go by the guidance. And it seems to me that Mr. Innes is changing the guidelines, and by putting forward their statement of case as fully as he did and wanting us to respond, we weren't ready to do that. In fact, we're still gathering evidence in the field, which is quite difficult at the moment, but as Mr. Innes explained, as we're sort of involved in going about a business purpose, then I'm still willing to go out into the field in this area. We live very far south in South Ayrshire, and we really don't have that many cases. The fact that we're with the central belt is a bit of a strange one, but there you are. So we are preparing our report, and we feel that we will be submitting it at the time the guidance says, which are the dates, and it's the same with noise. We're working towards that, and if we'd have had the guidance to begin with that we needed to put in a fuller statement of case, then we may have been prepared for it. So we're working towards that full report. And to go back, Dr. Rachel Connor, she will give most of the evidence on private water supplies, and we also have some interest in the geology as well, and want to use the full BGS maps as well.
Okay, thank you. No, that's fine. I mean, yes, we'd asked for as much of case, despite how it normally works in an outline statement of case. I think we just asked for as much evidence as could be submitted early on, just to clarify people's positions. But that's fine. If your intention is to submit an inquiry report at the same time as the other documents, setting out more fully your case, that's absolutely fine. Following that, and apologies if you know this already, but it might be unfamiliar to you. Following that, we would have a precognition from Dr. Connor, I assume. You said she'll be giving most of the evidence. So in terms of the inquiry on the day, the only people who can speak are those who've submitted precognitions, and they read or we take it as read. They read those precognition out, and then they can be questioned about it. So I just so as I understand, Dr. Connor will be doing that. Will you be doing that as well, or will you be relying on her completely?
No, Dr. Connor will be covering all the private water supplies and the water issues.
Okay, thank you. That's helpful. And so for Mr. Innes's witness, for example, he will be when his witness reads the precognition, at that stage we call it evidence in chief, and it gives an opportunity for Mr. Innes to ask his witness questions about what's arisen in the other evidence. He will then be his witness would then be cross-examined, and there's re-examination. So I just want to be clear: is it your intention to act, if you like, as the questioner, the cross-examiner? So would you cross-examine the hydrology witness from the applicant, or would you be intending that Dr. Connor is the one who asks the questions? Just trying to work out how we're going to run the session. Sorry for all the questions.
That's all right. It's okay. No, Dr. Connor, she will cover it all. Okay. She's quite experienced in this.
Okay, so your intention would just to leave it to her on the day. I mean, normally, Mr. Innes, a question for you. Normally, obviously, expert witnesses aren't protagonists in that way, in as much as they don't cross-examine. But I can see for Ms. Crothwaite the sense in, since she's not the expert, she has an expert there, that if it's a question of asking technical questions, then Dr. Connor would be the better place to do it than Ms. Crothwaite would be. So do you have a concern about running it in that manner?
Absolutely not. It's entirely up to Mrs. Crothwaite, and I obviously have no Dr. Connor, and think that would work very well.
Okay, that's helpful. Thank you. Mr. Campbell, the council's participation in this session is maybe a bit more uncertain, if you like, in terms of how it plays in. I guess we'll need to see the cases as they unfold. I think we'd put down 1 day for this, but we kind of have the Thursday in reserve. So I'm wondering whether 2 days is more realistic than 1 day.
Having heard Mrs. Crothwaite and Mr. Nisson's response, I think that's probably right. I was being excessively optimistic. So you should allow at least a day and perhaps a little spillover. We have, or some of us have, experience of these matters in other inquiries, and they do take a while. As to leading, because the council has now put the subject up in lights rather than dealing with it in a quieter way, I have no objection to that. I think that's, I wouldn't normally agree, but I think I see the sense in what's being suggested. But I'll leave that to your discretion. I certainly don't object to it, because there's an opportunity to come back in re-examination if something new is produced by, sorry, in cross-examination, something new is produced by the applicant's witness.
Okay, thank you. That's helpful. We so I think for our programme, we'll assume that Wednesday and Thursday of that week might be taken up. That's the 13th and the 14th by this session. Ms. Crothwaite, it's not something you need to answer just now, but I just put that out there that there might be an issue with Dr. Connors and your own, of course, availability on those 2 days. You can let us know if there is. If, for example, well, we'll deal with it. If Dr. Connors is available for both things, then that's great. If she's not, then let us know and we can see how we can deal with it.
Okay, that's fine.
Okay, thank you. Okay, if we can move on then.
And I suggest we take a short comfort break. We've been going for an hour and a half, believe it or not. So I think it would be helpful if people wanted to take a break, have a coffee and come back. I think we're on to noise next. Is that okay? We say 10 minutes, come back at 12:15.
Yes, thank you. So if you turn your video and mic off and then turn them back on again at 12:15, then we'll start again. Thank you, Alison. That's a very good idea.
This is taking a long time, isn't it?
Yeah, I think, although it's worth it.
Yeah, I know.
Yeah.
Just started to rain here. I was hoping it might be a bit quieter today. To do nothing but rain on the borders.
Good for the fishing.
Yeah, well, they say that. Only there were time.
It makes for very muddy walking.
Yeah, and site inspecting too. Oh.
Okay, I think that's us all back. But before I start up again, Mr. Stevenson, we weren't expecting you here, but it's good that you could join. You did say, I think, at the start that you couldn't stay all day, and it won't take us all day. But I just want to know: is there a time that you need to leave the meeting? Because if there is, we can move to your material first. Or...
Yeah, I can be here until 3 o'clock.
Okay, that's great. Well, I am confident we'll not need to stay that long, so thank you. If I was going to move on then to session 5, which is noise. So just to recap, Ms. Cothwaite had requested that we move this to the Tuesday the 9th and Wednesday the 10th of February. Again, similar to the last session to hydrology, we would propose an inquiry because of the technical nature of that evidence. But just on dates, Mr. Innes, I don't think you've confirmed that the 9th and the 10th are okay for you.
Yes,
I
we're fine. Yeah. Thank you, sir.
And do you know how many witnesses you're likely to have for this session?
We'd have 1 witness maximum, I think.
Okay, thank you. And Ms. Spence, for you and for Dr. Armstrong, are those 9th and the 10th okay for you?
I believe so, yes.
Okay, thank you. So, Ms. Cothwaite, just so as I understand your inquiry statement, as I read it, Melvin Grosvenor, he'd be the person leading the evidence on your behalf for your 3
That's
witnesses,
right.
Conducting the cross-examination, yeah?
Yes.
So he himself is not submitting a precognition or evidence, is that right?
No, I will be submitting it on his and our witnesses' behalf.
So right. So, Doctor, but in their names, what I'm assuming I would have is a statement, a precognition from Dr. Yelland, which he would speak to or be to which Mr. Innes would be able to ask him questions. Either
Yes.
similar, either the same from Professor Alves Pereira. So that's 2. I just wanted to know whether there will be a statement from Mr. Grosvenor or not, or whether he was limiting himself to being the advocate, if you like, the questioner.
Perhaps Mr. Grosvenor can answer for himself here. You're still on mute.
Sorry,
That's it.
I'm here, live and kicking. No, yes, I'll act as lay advocate for both Dr. Yelland and Professor Mariana Alves Pereira. I've done this before on previous inquiries in England.
Okay, that's fine. So that's fine. So I'll in terms of the evidence that is before us, there will obviously be the documents. There'll be a precognition from Dr. Yelland, another from Professor Alves Pereira. There won't be one from you, Mr. Grosvenor. Ms. Clothry, are you submitting a precognition? Do you propose to speak and be questioned, or are you leaving it to your other witnesses?
I'm leaving it to my other witnesses. Unless, actually, we've done quite a lot of work in the field, so it might be that there might be cross-examinations on the on the site visits and things, and so maybe I will need to be cross-examined on those because they're quite important.
Sorry, do you mean have a discussion on site, or be questioned about the site visits? I wasn't quite clear.
I mean to be cross-examined on the sites, the actual sites that have been monitored.
Right. Okay. So, I mean, I'll come back to Mr. Innes, give us a view on this. But I suppose, in my experience of working of inquiries, the only people who give evidence and can be questioned are those who have given a precognition. So although you might have been involved in work with your other witnesses, unless you've given me a precognition, then you wouldn't normally expect somebody to be cross-examined without being the one that's given evidence. But let's park that a minute. So I'll have one witness from Mr. Innes, from the applicant rather, with Dr. Armstrong. For Ms. Spence, we have Dr. Yelland and Professor Alves Pereira, and possibly yourself.
Yes. So therefore we would all put in a precognition.
Right. Okay, that's fine.
Yeah, that's fine.
That's fine. That's excellent. So that's 5 witnesses. We've programmed in 2 days. Again, I suppose I'll ask Mr. Innes because he may have more experience. And Mr. Grosvenor, of course, does 2 days seem like it's going to be enough?
Yes, it will be enough.
I would think so, yes.
Okay, that's excellent. Okay, is there any other questions about that session? That's all I wanted to ask, just to clarify those points, but I'm happy to move on. If
I sort of renew my position regarding still having no clear picture as to what the actual case is that's being made. And equally, I think the fact that one party is potentially leading 3 witnesses and etc. is fairly clear where the bulk of the evidence is going to be led in the context of this matter. And I think it would be far better if that was out up front and first, rather than effectively me trying to put in examination in chief what might or might not come forward in documentation. I just say it just in terms of it being more straightforward to run in a virtual context, rather than, because one of the things about virtual again is I'm assuming that most of the precognitions will be taken as read, and we'll be trying to keep them the momentum and that space time for people actually asking questions, because essentially it's that value of the space time is really important, and therefore want to be minimising that, and I think that would probably be minimised by that approach.
I think we're also still waiting as well for a full cumulative noise assessment impact from yourselves, as with the cumulative landscape. And going back to that, I think it would be very helpful if we all got the actual documents for landscape. I think that Miss Ellis probably needs more than just the one wire line. She needs the full new documents of the cumulative landscapes too. And I think we need to see them as well, because obviously for both hydrology and noise, the topography is hugely important.
Okay, so sticking to noise just now, I Mr. Innes,
I'm not aware of it.
I'm not aware of anything
any.
else.
No, as far as I'm concerned, you're getting nothing else. So I don't know what's been asked for.
Yeah. So yeah,
sorry. It was raised in the first PIM meeting. It was raised at the same time as cumulative landscape. I raised it that we needed to have a full cumulative noise impact assessment as well, including clockery.
Yeah, yes, no, indeed, you did. But what I suppose what I'm saying is I've not heard that in response that the applicant is proposing to do anything. So that to submit that information.
The clockery information is available if you feel there's a benefit in having that material before the examination or the inquiry, you could do so. It's fully available. It's published documentation. I don't see any need at this stage to lodge anything from clockery in relation to noise. But if Mrs. Crothwick wants to do so, she can do so. But the information is there. It's not hidden. We're comfortable with the cumulative assessment that's been submitted.
But the cumulative assessment that's been submitted doesn't include clockery for Arecleoch extension.
So I don't want to get into the merits here. It's for each party to submit what evidence they think is necessary. If the other party thinks that that's insufficient, or leads to a hole in their evidence, then well, that's something we need to discuss at the inquiry rather than now. So we have 5 witnesses. Ms. Crosby, for both this and the previous session, Mr. Innes suggested that the objectors go first, if you like, in terms of their evidence. Alison and we can take a view on that once we see the evidence, but at this stage, I can see why it's been suggested. Do you necessarily have any comment to make on that prospect of your witnesses being the first to give evidence, followed by the applicant's witness?
Yes, I don't think that's a problem at all. Could we have dates when we need to give the full report by now? Because with the dates changing, it would be very helpful to know what we're working towards. Because we have been doing quite a lot of work in the field, and it's been very difficult because of COVID. And obviously, my witnesses can't actually visit anymore. So I'm doing a lot of the groundwork as and when I can.
Yes, no, that's fine. We'll come back.
We'll cover that in detail on item 6. But what in effect would be that the deadlines for this session would tie in with the ones for the second part of oral sessions, so that you'll have more time than you would have had if noise had been considered in January. But I'll run through the exact dates whenever we go through that part of the agenda.
Thank you.
Okay, thank you. So, I'll move on to session 8.
David, Miss Spence.
Oh, I'm sorry.
Thank you. I'm not used to being ignored. I think that it's very important that the topography of the area is considered, and I think that the SPR noise calculations, predictions have been done on a flat plain. We do not live on a flat plain. I live at the top of a hill surrounded by high ground with low ground in between. The topography is very important, and the cumulative effect of all these turbines.
Ms. Spence, sorry, I apologize for cutting in, but I don't want us to get into the merits of the evidence just now. It's just about procedure. I'm just concerned.
I'm just trying to make it clear to you that how important the cumulative evidence is, because that is what I'm living with every single day, 24/7.
Okay, thank you. No, I mean, I understand that point, and it's something that presumably your evidence would get into. Apologies for cutting you off. I just want to make clear, we can't take account of anything we hear today when we actually write up our report. It's
yes, but you dismiss as though it almost is so unimportant the actual importance of cumulative evidence combined with the topography of the area. And
well,
I just feel that I need to make that clear how important that is. And then also, I think that the evidence that SPR has supplied on noise is totally inadequate.
Okay, well, yes, hopefully we will address those on the 2 days we have and in the written submissions prior to that. Okay, if I can move on then to session 8, which is the overview of effects and infrastructure implications. We propose a hearing session for this on Tuesday, the 4th of February in the afternoon. I think both the applicant and you, Ms. Spence, have confirmed that date's fine for you.
I give it Thursday the 4th, just for
Thursday the 4th. Sorry, did I get that wrong? And Mr. Andrews, the 4th is fine for you. Okay, thank you. And we presume that Ms. Spence, neither you or Mr. Andrews, you're not calling any witnesses. It's you yourselves who are taking part in that session. Is that correct?
Yes. I don't know. You have to ask Mr. Andrews if he's because we've not discussed that between us. We're covering different areas.
Well, I am looking into supplying a witness, but I have no details as yet to give you.
Okay, so that's fine, Mr. Andrews. You can let us know when you know. But that's fine.
Okay.
So we have your original objections. We have the evidence from your statements of case, and we'll of course take that into account. You have the further opportunity of making hearing statements, and Alison will come on to the dates. You don't have to submit a further hearing statement if your written evidence is all before us, but that's the opportunity you have. And then we would move on to the hearing. Mr. Ennis, that all seems straightforward. Mr. Ennis, have you anything to add on this, or we have to move on?
No, very, very comfortable with that. Thank you, sir.
Okay, then if Ms. Spence and Mr. Andrews are content, then that's fine. Now, session 9 is in relation to SF6 gas. Now we've slotted this in on the morning of Friday, the 5th of February. Mr. Innes, I think I saw this morning that the 2 technical updates papers, I haven't read them yet, but I've seen them come in by email. Were circulated, were provided. So, Ms. Crothwaite, just I'm happy to talk about it. My suggestion would be these have come in. You have an opportunity to submit your hearing statement on this subject. So it seems to me that that would be the opportunity to make any response you wish to make to the new material provided by the applicant. Does that sound a sensible way to do it?
Yes, I saw that these came in yesterday, but I haven't had a chance to look at them. But yes, that's fine.
Okay, and then I haven't thought through this in any detail, but your hearing statement can respond to those documents. At the same time, the applicant could submit its own hearing statement if it wanted to, and then maybe after that, I mean, I assume we would. I work on the assumption, Ms. Cothwaite, that you would still want to have a hearing, but if on sight of these new documents and in making your response, if you're content to rest in your written submissions, then that's fine. You can let us know. But I'll just leave that as a matter for you to think about once you've seen this evidence. We'll proceed on the basis that we'll still have a hearing unless you tell us otherwise. Is that okay?
Yes, that's absolutely fine. Yes, I've got someone looking into this for me in detail, so I would need to confer with them before I can come back to you. But yeah, that's fine.
Okay, thank you. And then finally, my apologies, Mr. Stevenson. It's only last because we didn't think you were going to be here. There was nothing else in that. So we have. To recap, we had your original statements of case in this. We had a response from the applicant, and then we had your rebuttal. And what we have programmed in is an opportunity for you to submit documents and a hearing statement, if you wish, and then the hearings themselves. Is that still how you want to proceed? Having gone through the written submissions, I suppose, is there more in writing you want to put in, or do we just move straight to the hearing?
Well, in rebuttals, asked for a lot of information. I need to know if that information will be, and I've had time to study it. I'll be able then to participate in a hearing, which I'd be perfectly happy to do. Sorry, my phone is going now. My apologies.
No, that's quite all right. So, okay. I mean, it will be for the appellant. I'm sorry, Mr. Ennis. It'll be for the applicant to determine what, if any, further evidence it wishes to submit in response to your statements. I don't know if Mr. Ennis wants to say anything at this point.
The issues are relatively far advanced. They're certainly at a state where I think, from a hearing perspective, we've got enough of the interchange for it to be kind of. I will look at the rebuttals to see if there's anything that we should or should not be coming back on, but we'll do that at the appropriate time.
Okay, that's fine.
Okay, thank you. So yeah, so we'll just see what further documentation is provided, and then we can see the hearing statements. So, and Thursday the 4th, Mr. Stevenson, that's it, yeah.
Thursday the 4th is fine. Yeah, thanks.
Okay, thank you. Okay. That's great. I can move on to item 5, which is about conditions, which won't take us too long, I think. So we have. I don't know whether you've seen the conditions which the applicant and the council agreed. Mr. Ennis, were they forwarded to the other parties? I just can't remember.
I hope so. I seem to recall that they were.
Yeah, people were. I think people were nodding. So yeah, okay, that's fine. So we've had a look through them. So we'll have a few questions about the conditions. What we'll probably do is put those in writing and ask for the council and the applicant to come back on those. But I wondered whether any of the other parties wanted the chance to submit comments on the conditions. Ms. Crowthwaite.
Yes, we've got issues with the operational noise conditions, so and that will form part of the evidence that we submit. So we would like to reserve that they should not be agreed at this point until the evidence has been seen.
Okay, yes, I appreciate there might be some crossover between a general discussion about conditions and some of the specific topics where conditions are relevant to them. So I think I'll discuss this with Alison afterwards, but I think our thinking is probably that we would issue a general invitation if anyone wants to make comment on that suite of conditions. And they're not all agreed between the council and the applicant yet. There are areas of disagreement where ultimately we will have to take a view in our report as to what we think conditions should or shouldn't say. But my proposal is that we would give anyone who wants to the chance to comment on the conditions as they stand now. We would add our own questions to that, and then the council and the applicant would have the chance to respond to all of that together. That just seems like the neatest way to do it, I think. And just to clarify how it works, we would then write our report. If at the end of those, sorry, before that, if at the end of those written exchanges, we think we still need a hearing because we're not clear or we want to probe a little bit deeper, then we've reserved a day for that. And anyone who wishes to take part in that hearing, if we have one, we'll be able to do that. So we can settle that out in the note of the meeting. But that, unless anyone's got a point to make, that's how I'd be proposing to do it. Ms. Spence.
Sorry, I switched myself off again. The conditions, I made a suggestion with regard to topic 8, that the applicant should put forward a large amount of money because of the things that happened during the Kilgalliot construction and the inconvenience that everybody in this area suffered. It was absolutely massive and it went on for a very long time unnecessarily. So I have suggested that a large amount of money should be put up front so that people don't hang around waiting for things to be put right that they have caused through their negligence.
Okay, that's fine. So there's two ways to do this. As I said, we're going to give people the chance to comment on the conditions, and you could repeat that. But what I suppose I could maybe just highlight for the applicant and for the council that you've already made that suggestion in your topic 8. When they come to respond to our questions and to the other people's questions on the conditions, perhaps they could just make a note that we'd want them to respond at that time to your point as raised under topic 8, and then you don't have to repeat it in the next round of correspondence. Does that sound sensible?
Yes, yes.
Okay, is everyone else content with that process? You don't have to tell us now whether you'll be commenting on the conditions. It will just go out to everyone and then you can opt in if you like. Okay, I think that's everything under issues 4 and 5. Have I missed anything out important, Alison, that you can see, or can I just pass on to you?
No, I think we've covered everything that we hope to cover.
Okay, over to you then.
Okay, thank you for your patience, and hopefully this won't take too long. So item 6 on the agenda is the submission deadlines, and obviously we've touched on some of these, and I've been taking notes where things have been evolving through the time scales of the meeting. So we'll try and firm up now, but I'll make sure that the meeting note will set out all the details if you don't get all of them. So first of all, I want to cover the core documents, our timetable was that by next Friday, all core documents to be lodged by the applicant. I recall when the applicant submitted its list of core documents, we asked parties to get back to the applicant by the 30th of October if they wish to add any documents to that list. Maybe Mr. Ennis did. Have we anything else on that list, or we're still working?
No, nothing came back. So as far as I'm aware, everyone was happy. The core document list was very extensive. So hopefully that's as a consequence of that extensive list that nobody felt we were missing anything.
Parties obviously will have the opportunity to add documents their own list, but the experience that Mr. Kelly was referring you all to at Glenshero and the other virtual inquiry that seemed to work well was that we work from one list of documents. So basically the core documents list by the time we get to the oral session becomes everybody's documents, and the applicant takes responsibility for keeping that up to date. The benefits that it worked in terms of the USB sticks and see the alternative through the hub may work equally well was just making sure that everybody was referring to documents in the same format with the same numbers. So it helped whenever people were being asked to cross-refer to a document that everybody had the same version. So hopefully, I say the intention is that we use our lessons learned with that good practice, and we come up with a procedure that allows everybody equal and fair access to the documents in a way that they can use easily at the sessions. So,
can I ask a question?
Yes, certainly, Mr. Beckett.
Yeah, I'm just picking up one or two things from the applicant. Just wondering whether he is proposing to submit any new material with regard to site layouts, etc. Other than I'm assuming the one that you, Madam Reporter, referred to, or referred me to rather, is still the extant one. Is that the case, or any kind of changes anticipated?
Mr. Ennis, are you able to?
Yeah, the application is as submitted.
Right. And
there is no intention at this stage of the process to alter the project at all.
That was my understanding.
Yeah.
Okay. That's useful to clarify that for parties. So in terms of dates of submissions, then, if we work on the basis that the documents list as produced by the applicant, it'll be lodged. I assume that'll be on the hub then, Mr. Innes, is that the?
Well, what I've said is that we're prepared to set up the hub, but we're also prepared to send documents through a stick. Now, it's a question of whether you get a stick at every stage of the process, or whether you get one at the end just before we collate it, or otherwise we're going to be sending a lot of sticks out. But that's not really the issue. It's how often that happens. Yeah. Does it happen at stages? Do we have, for example, I suspect that a lot of people would want the core document list as a stick as soon as possible, because there's a lot of documents there that will be core to everything else. So I'd have thought that would be a natural inclination to have an exchange. In terms of the hub, it would be continually updated as we go. So that's not, it's just how often.
I've started to, I've looked at the procedures for Glenshero, and I think we will need to tweak them a bit, because we've got the sort of two parts to the oral sessions, and whereas they were putting everything in as they were running in consecutive weeks. So it might be that we have sort of two, and there seems to be cut-off points for getting everything updated. So it's something that we could certainly work with the applicant to agree when things get updated. But the main aim is that everybody has the documents they need at the right times for preparing their recognitions and their statements, and that they've got everything in front of them when they're taking part in the oral sessions. So we may need a bit of sort of testing of how it works, but that would be the principle of doing that. But it will require all participants then to meet their deadlines in terms of any documents that that they're lodging for the sessions, to make sure that those are made available for the applicant to collate. Yes, Ms. Ellis.
Sorry, I've got a very basic question that I'm not quite clear about.
That's fine, no problem.
When we send in our list of documents, R1, do we have to specify each part of a detailed, say it was a visualization? Do we put the actual figure number down, or do we just say refer to core document such and such? How detailed do we have to be?
It's helpful if you can be as detailed as possible, because then it allows everybody to have that visualization number in front of them, and that they know exactly what it is you're referring to. It saves time, and it also avoids misunderstanding of people not being not looking at the right document. So the advice would be as specific as you can.
Okay, thank you very much. Thank you.
So in terms of the other time tables, we agreed then that that the hearing statements for topic 1, which is the policy, would delay that till the 18th of December. And that would then mean that the before that, then Friday the 11th of December, the participants' documents for topics 1 and 4. So the topics that are taking place in January, the policy session and the hydrology, any documents or inquiry reports that participants want to lodge would need to be ready by Friday the 11th of December. And then the precognitions for the hydrology session would be Friday the 18th of December. Yes, Ms. Crosthwaite.
I wonder if I might have a moment on that topic.
Yeah.
The environmental health officer has a medical commitment in the first week of December, which will take her out for the entire working week. So on the hydrology question, could I ask you to make an exception and advance the date by a further week? I'm sorry to be awkward. I've only learned about that last night. And
that takes us to Christmas. That takes us to Christmas Day.
I thought you said the 11th.
Oh, right. But the recognitions is the 18th. Query documents is the 11th.
I'm waiting for some freedom of information documents to come back, and I don't think I'll have them back by the Friday the 11th. So can I have an extension for that?
Mr. Ennis, how are you placed in terms of, because obviously from the applicant's point of view, if they wouldn't then have your documents to prepare their recognition in relation to, which, given the comments, I suppose that Mr. Ennis said beforehand, it would be difficult for them.
At the moment, I do not know the case that's going to be made on private water supplies at all. That is a bit concerning. And normally at this stage of the process, we at least have some idea of what we're facing. It's not ideal. We will seek to manage it as best we can, but the earliest possible disclosure of the case is important. And it may be, I would encourage that there should be as early a disclosure as possible of the hydrology case. And I think it's very important that that is done. A week is, is very short time to digest the whole case. I don't know how many documents, reports from 2 parties that have been working at it for months with site-specific issues raised. It is quite challenging, but equally, if there's a problem, there's a problem. but I don't want to start trying to preempt things until we've seen what the information is. But at the end of the day, if, for example, there is a problem with Mrs. Crosswaite not being able to submit all her information on time, and there was something came up afterwards, fine. But the difficulty is that we're now getting to the stage of the timetable looking a bit challenging over Christmas. We will manage it, but it does require the documents to be lodged and the case effectively to be lodged on hydrology in advance to allow us to respond to it. And I think if we're leaving it to the 25th, I think that's a bit late.
If we put this to Mr. Campbell and Ms. Crosswaith, would it work? Well, for Mr. Innes as well as comments, would it work if you submitted, I suppose, the inquiry documents as far as you have them on the 11th, with the opportunity to finalise by the 18th, which would then give Mr. Innes, and that would give the applicant something to work on. I think we'll also have to pull the recognition date back from the 18th, but at least it would allow the applicant to get started.
As far as the council is concerned, I think we can do a wee bit better than that. I would accept that offer gratefully, but this is clearly now a priority matter. I hear what Mr. Innes says. It's unfortunate that this has come along just at the last minute. But I think what the team would like to do at the council is work at this next week and to produce an outline statement of the hydrology case so that Mr. Innes has an idea of what he's facing. But I can't promise the level of detail, but I can certainly promise an outline. There's GIS material to do, which takes a little while. There's probably some site visits to do, which take a little while. But I have the bones of the case ready in front of me. And looking at it again, as you've been talking, I don't see any problem with putting together an outline case in the course of next week.
I can agree totally with that. We have our outline case ready, but there are some things, and there are still some field work things to finish as well. But we can put together the bones of the case next week and submit it.
That would be really helpful. And yeah, you just sort of highlight the gaps where there's more to follow. Then does that work okay for you, Mr. Innes?
Yeah, that is extremely helpful. I'm most grateful for both Mrs. Crosswaith and Mr. Campbell for those kind offers. I think it's a positive way of working. Yeah, thank you.
Okay. So on that basis, then, do we stick with Friday the 18th for recognitions on the basis that we might need to knock it back a few days if things aren't quite ready?
Yeah.
Yeah.
Would that be okay?
Alison, I'm sorry, can I just, I'm just taking notes to help us at the end. Are we saying then, we're talking about next week for documents, so it's going to be the 4th of December for documents for this session, is that right?
Well, I think there'll be a draft. Sorry, where am I? Yeah,
when I was offering the documents next week, I was offering a draft outline, an outline statement of case on hydrology only, on the understanding that it is what it says on the tin. It's an outline statement of case, not the case I want to make it an inquiry, not the full case I want to make it an inquiry.
And do you have, well, at that stage, you have your list of documents that you can make available for?
I hope so. I don't know, but I hope so. It's very difficult when you're not on the spot,
yeah.
To be completely confident about that. But there's a limited amount of documentation in this regard. There's some legislative material and some graphic material. If I can get the graphic material made as quickly as possible, then we're 3/4 of the way there. So
given the time, obviously the 4 parties or the 3 parties and ourselves that are involved in this, I think if we follow this up with correspondence after the meeting, just to finalise the dates and get something that works for all of you. It's just testing our flexibility. Okay, so the other thing that we need to tie up is basically a date at some point before the start of the first session for the applicant to circulate a final list of and documents So that's where either on the hub or on the USB stick, so that everybody before the session start for 1 and 4 have everything in front of them. But we can clarify, we can confirm that date. I've got down Wednesday the 6th of January, but sometime that week before things start on the 11th.
Yeah.
Okay, can we move on to the February sessions then? In terms of dates, so this would be for topics 3, which is the ecology, and 6 to 9, so the transport, so the 3 that Mr. Stevenson's involved in, and the SF6 gas and the overview of effects. So if parties wish to submit hearing statements on those, in addition to what you've already submitted, those should be in by the 18th of December. Is that okay for everybody? Take that as a yes. Now, in terms of other participants' documents, again, and this is what Mr. Innes, the matter you raised in response to Mr. Kelly's. Initially, we had said Wednesday, the 6th of January would be when all parties could access everybody's documents for the sessions, including the query sessions in part 2. Can that be brought forward? Is it? I mean, I suspect that Mr. Kelly is going to be interested in the council's sort of landscape and visual evidence. Everybody will have sight of the applicant's core documents from next week. What would be missing is each other's documents on landscape and visual and the other.
I'm not prepared to commit for Ms. Anderson without speaking to her.
That's fine. We can follow that up.
Follow it up without.
Yeah.
So tell me which date you're suggesting. The 18th.
We suggested Wednesday, the 6th of January.
6th of January for the inquiry report.
Yes.
Okay.
If it assists, given the level of general agreement and the nature of the topic, in terms of landscape and visual, from the applicant's perspective, and we've really set out our position already,
yeah.
If at the end of the day the preconditions were delayed a further week into January, I don't think that would cause us a problem and would give Mr. Kelly a bit more time, and equally it would give everyone a bit more time to finalise whatever they wanted to lodge. And I say that partly because it's a much more advanced topic. It's there's large areas of agreement, and the disagreement, even from many of the objectors, is very clear. And so I think that could be accommodated within that timetable. And I appreciate that reduces the timescale for some of us having to read quite a lot of preconditions, but so be it. I think that might be fairer to Mr. Kelly than bringing forward the date, which I think, as I said, Mr. Campbell's alluded to, might be a problem for others. So
that would be precognitions for landscape and visual due on the 15th of January then.
Yes.
What do other parties feel about that?
So are you asking me? I think we'd be happy with. I think we'd be happy with that. I could probably check now if you want me to, but if you'd rather we did it in correspondence after this meeting.
Yeah, I think that's fine. We can follow it up.
Okay.
We've got a bit of flexibility. Obviously, what that does mean is that you would be working in those recognitions the same week as the first week of the oral sessions.
Of course.
Which might be.
It's fine. I would have one precognition to, and I would hope that we'd be a fairly advanced stage. So I certainly think it's what I'm thinking of was primarily Mr. Kelly's point about having a bit of a gap between the documentation any documentation being lodged and him having to submit. I would add on behalf of the appellant that our material is all submitted. And we've already said roughly what our position is. So there's not going to be a vast amount. And I think he's concerned, but I'm conscious he is not here.
Yeah.
And I do want to make sure that his points are raised, and I think that would meet his concern.
I think
hopefully.
for yeah, I think obviously for all parties, just because the deadline's moved back to the 15th, there's nothing to stop you submitting it on the 8th if you want to get it in before you start any of the sessions the week beginning the 11th. David, you want to?
So the 6th and the 15th, the 6th and the 15th are the 2 dates you're penciling in just now.
Yes.
Is that right? Yeah, thank you.
David, you got a...
Yeah, I was just going to ask, just for Mr. Innes, just so as I understand you, and it might be that we can put this in the note and that would help Mr. Kelly. We're talking about the council having an inquiry report on landscape and visual on the 6th of January, subject to Ms. Anderson's ability. Were you saying there that you wouldn't be doing any further inquiry report?
We may do a short one, but I mean, we've largely set out our position as in the initial notes. I mean, at the first pre-examination, I made a commitment that we would set out our position to try and assist this, and that's what we've done, and to update parties of where we stood on these matters. So I don't think it's not going to be anything lengthy, and it may just be recognition. There's not going to be a very lengthy inquiry report produced on behalf of the applicants.
Okay, that's fine. Yeah, so you're not going to have another consultant go out and do another exercise and say I agree with you.
No, absolutely not.
Okay, so yeah, so the 6th of January or earlier, if the council's landscape witness is able to meet that, but then if not, and we may disagree anyway, that the precognitions for topic 2 can come in up until the 15th. It can come in earlier for anybody else that wants to get it done and dusted before they start any sessions on the week beginning the 11th. Is that okay?
Yeah.
Okay, so we've got a recognition deadline for noise to be in on the 8th of January. Is that okay for parties, Ms. Crosswayton, Ms. Spence?
That's for the full report, is it? The 8th of January.
No, that would be your precognitions. Your full report would be in on the 6th, and your precognitions would be in on the 8th.
Well, could we have more than 2 days, please, to do the precognitions?
Are you able to make the 6th for the inquiry reports? I suppose that's probably of most critical, I would have thought, for the appellant, for the applicant.
Can I just ask Melvin to come in on this?
Of course you can, Mr. Grosvenor. Still muted. Sorry. That's you now.
I'm back now. You're saying for the 6th of January for our full report on noise?
Yes. We had the precognition penciled in then for the 8th, but we could maybe push back the date for the precognition as long as we got the inquiry reports in by the 6th.
I would think so, yeah.
Okay, that's helpful. Mr. Innes, does that work for you?
Yeah, I honestly don't know what I'm going to face on the 6th, and it does concern me if there's a vast amount of technical information of how a witness is supposed to potentially deal with a whole series of reports and respond when there really hasn't been a lot of specific prior notice of what it's all about. So it's the one area of technical issues are always more concerning than things like landscape and visual, in the sense of it does take more time to understand. I would have preferred it earlier, but I think, I appreciate timescales, provided we get 2 weeks in which to do our precognition and response.
Right, so if we say they wouldn't quite have that. If we were saying it came in on the 6th, then we'd give you to the 17th for recognitions.
Oh, we'll have to go with that. Yeah.
Again, in the flexibility, if when things come in on the 6th, there's something that means that those timescales aren't deliverable, then we can have that conversation.
Yep.
That sound Okay, nearly there. So we will get our hearing agendas then out for the sessions in part 2 on the 8th. And then again, we need a date, probably Friday the 22nd of January, for the applicant to pull together all documents and make sure everybody's got access to those before the sessions start. So I think we've got an agreed way forward in those. To say we'll confirm all the dates, because I know that they've changed a bit the paperwork that went out with the agenda. So if we'll get these out in notes, and if there's any particular issues, if you can come back to us as soon as you can for us to address any difficulties. Does that sound okay?
Yes, thank you.
Yeah, thank you.
Okay. Right, we move on to site inspections. So since the last meeting, David and I have been back out to the area and done another full day of unaccompanied site inspections, and so thankfully we were able to do this before the current round of restrictions. We have our convoy of one car following the other, so we're doing it all in a socially distanced way. As I alluded to earlier, it's now been agreed that no DPA site inspections will be undertaken in the level 4 areas until these current restrictions are lifted. So I'm very thankful that we did get back out. Now, in terms of moving forward, we're only going to carry out accompanied site inspections where necessary. So if there are any locations or any particular sites where people consider that we need to visit on an accompanied basis, if you could let us know that as soon as you can, so that we can make the necessary arrangements. Now, just in terms of Ms. Crosswaite, reading through your submission on noise, you have asked that we visit intended monitoring locations.
That's right, yes.
Yep. I noted that there, from the figures in the EIA reports, that there's 4 historic monitoring locations and 5 new ones. Are you wanting us to visit them all? And if so, what is it you want us to look at? I suppose that if you can just give us some sort of clear direction as to what exactly you want us to look at, that would be really helpful.
Yes, okay, and we can send photographs as well, and you know, sort of aerial views and things, so which will help. So maybe we could do that in writing.
Yeah, if you could do that. I mean, we can say we'll make arrangements to visit either before the noise sessions start or afterwards. But it's important that we're clear, that we don't misunderstand what it is that you want us to look at. The other point is that in paragraph 31 of your statement, you refer to a property called Craignance. Just that's not mentioned anywhere else, so it'd be really helpful if you could provide us with the grid references of that property.
Yes, okay. It's not actually plotted on many maps, but it's a fair. Well, I don't know when the bungalow was built, but yes, I'll provide the grid references. That would good. Now, are there any other particular locations that people want us to visit? If so, if you could let us know by the end of December. So either in your hearing or inquiry statements, or by email if they're not in by the end of December. If there's specific locations you want us to go to on an unaccompanied basis, then let us know. If it's accompanied, the earlier you let us know, the better.
Of course.
Okay, and hopefully by then we'll all be free to move around. But David and I will juggle that from our end. Anything else on site inspections? Silence. That's good. Okay, we're nearly there. That covers everything that we need to discuss. Any other procedural points or questions that anybody wishes to raise?
I've got one, and that relates to hard copy visualizations, because when Mr. Kelly requested the various copies, I noted that there was commentary about others requesting them. I mean, these are lengthy copies, and they are, Mr. Kelly is going to get 3 sets of visualizations for Arecleoch extension, Clochry, and I think he was also after Kilgallich extension. Other parties seem to indicate that there might be a willingness for some people to get them locally. I mean, it's quite an ask, but if I think there was if somebody, as I say, if somebody wants them, I mean, we will try, but I can't promise that we'll get 10 copies, for example. I think that's probably quite difficult to achieve within the timescale, but we could send, to those who are perhaps most interested in the wider context, could have those.
Well, I think if I could have a full copy, I can certainly share them with Miss Ellis and Mr. Stevenson if necessary, and possibly with Miss Spence as well. So, or maybe you could send 2 copies down to this part of South Ayrshire, and we could share them.
The council would like to set Colin, please, but of course they don't have to leave Edinburgh because Ms. Anderson is there. But perhaps you can liaise privately with me to get those delivered.
Yeah. Okay.
Can I just give a warning that if you are sharing documents, you make sure you do it in a COVID safe way?
Yes, of course.
Need to look after you all.
Maybe in that case we need 1 set each. I mean, I'm sorry, Mr. Innes, but we're very willing to share, but we do have to take the guidance into.
I mean, it may be that if one's provided, once you see what it entails, you may be able to take a better view on whether or not you want multiple copies. They are a hefty tome, as I carry them in from one room to the other, and my kids go, "What is that now? This is just the EIA." And that's just for Arecleoch extension. So it's there certainly is. There's a lot of trees have gone into those. Okay, well, say if you can confirm how many are needed from the village. So anybody got anything else? Any other matters? So in terms of next steps, obviously keep liaising with Jane, and if you submit things next week, even though Jane's taken a very well-deserved holiday, her inbox will be being monitored, and they'll be picked up and passed on to and I and dealt with. And submissions need to go to the case officer and copied to other parties. And we've got the updated circulation list, and we'll be resolving the issue of the blind CC. Seems hours ago that we discussed the blind CC issue. We'll circulate a note of the meeting, and as we get near the time, following the good practice from the other virtual inquiries, we'll prepare a procedural protocol in advance of the oral sessions. So that will set out any matters in terms of how it's run, and hopefully it'll all go smoothly. So on that note, David, do you have anything else you want to add? Okay, and just remains for me to say thank you very much to you all for your help and your participation today. I think we've made a lot of progress. It has taken us to 1:20, but so have a well-deserved lunch, and I'll now formally close the meeting. Thank you.
Thank you, everyone.
Thank you.
Thank you. Bye, everybody.